Mr. President, I'd also like to take a couple of minutes to discuss a bill I'll be introducing with Senators Coons, Graham, and Whitehouse. It's called the Clarifying Lawful Overseas Use of Data Act, or the CLOUD Act. It's a tremendously important bill that will help solve the problems that have arisen in recent years with cross-border law enforcement requests. The rise of email and cloud computing has put our data privacy laws on a collision course with the privacy laws of other countries. Information in emails or in the cloud can be stored on servers virtually anywhere in the world. This means that when law enforcement seeks access to such information, the information may be located in another country. This state of affairs causes problems both for law enforcement and for email and cloud computing providers. It causes problems for law enforcement because warrants traditionally stop at the water's edge, because laws in other countries may prohibit disclosures to foreign law enforcement. And it causes problems for email and cloud computing providers because they find themselves caught between orders by U.S. law enforcement to disclose data in other countries and laws in those other countries that may forbid such disclosure. The question of whether warrants issued to U.S. based providers may require providers to disclose data stored in other countries is currently before the U.S. Supreme Court in the United States v. Microsoft case. Oral argument in the case will be heard later this month. No matter how the court rules, however, problems will remain. Either law enforcement will lack the ability to obtain in a timely manner email and documents in the cloud that are stored overseas, or providers will find themselves caught between conflicting domestic and foreign laws. The CLOUD Act creates a clear, workable framework to resolve these problems. The bill has 4 key components. First, it authorizes the United States to enter into bilateral data sharing agreements with qualifying countries under which the United States agrees to lift its bar on disclosure to law enforcement in a qualifying country if that country similarly agrees to find or to lift any bar it has on disclosure to U.S. law enforcement. The CLOUD Act sets forth stringent requirements for such agreements in order to ensure privacy and data security. In particular, it provides that any request by foreign law enforcement to U.S. providers under such an agreement cannot target or request information on U.S. persons. Second, the CLOUD Act clarifies that a warrant served on a U.S. provider may reach data stored overseas, provided the data is within the provider's possession, custody, or control. This will enable U.S. law enforcement investigating crimes to obtain information stored overseas without having to reason or resort to cumbersome diplomatic channels. Third, the CLOUD Act gives email and cloud computing providers the ability to challenge a warrant issued for data stored overseas if complying with the warrant would cause the provider to violate the laws of a foreign country. The court hearing such a challenge determines whether, in the interests of international comity, the warrant should be modified or quashed. Finally, the CLOUD Act authorizes providers to disclose to a foreign government the fact that the provider has received a warrant for information stored in that country, provided the foreign government has entered into a bilateral data sharing agreement previously described. This will enable the foreign government to assess compliance with the terms of the agreement and intervene diplomatically if it believes the request is inappropriate. The CLOUD Act has broad support in both the tech community and among law enforcement. It bridges the divide that sometimes we see between these two groups. The bill is an outgrowth of my International Communications Privacy Act, or ICPA, coupled with the U.S.-UK bilateral agreement framework that many of my colleagues are familiar with. Indeed, the U.S.-UK bilateral agreement framework outlined in the Cloud Act is intended as a model for future agreements between the United States and other countries that are committed to privacy, human rights, and international law enforcement cooperation. Expeditiously implementing similar agreements with the European Union and other allies is critical to protecting consumers around the world and facilitating legitimate law enforcement investigations. I'm pleased to be introducing this very important landmark legislation with my friends from Delaware, South Carolina, and Rhode Island, and intend to push hard to see it enacted in the very near future. Mr. President, I yield the floor.